Welcome to the Deep Dive. Today, we're really getting into the details of the Mazi Nnamdi Kanu court hearing from May 6, 2025.
Yeah, we've got the court transcripts from that day.
Exactly. And our goal is, well, to unpack what actually happened, especially around some key moments and procedural issues that came up.
It's quite revealing looking at how these things play out in real time, particularly with evidence.
Absolutely. So it kicked off with the defense finishing up their cross-examination of the first witness. They asked some pointed questions like, was this witness, who apparently played a part in Kanu's apprehension, was he consulted before the charges were actually filed?
And the answer was?
Yes, he said yes. But then they asked if he knew about the initial 15 counts.
Okay.
And he said no, not aware. Then they asked if he knew those original charges had been struck out previously.
Let me guess.
He didn't know that either. Said he wasn't aware.
That's interesting. The defense seems to be sort of chipping away at the foundation, maybe suggesting a lack of internal consistency or knowledge from the start.
Could be. Then the prosecution brought in their second witness.
Okay, moving on.
And this witness straight up identified Mazi Nnamdi Kanu as the leader of IPOB, calling it proscribed.
Right, that's the official designation.
And also stated Kanu set up the ESN, the Eastern Security Network, labeling it an armed terrorist group. Pretty direct testimony.
Yeah, that's laying out the core of the prosecution's case right there, linking him directly to IPOB and ESN as an armed group.
Definitely. But then things got, well, a bit more complicated during the cross-examination of this witness.
How so?
The prosecution tried to introduce a letter from the Attorney General of Nigeria, no less.
Okay. Was it part of the evidence list?
Well, that was exactly the problem. The defense counsel, ADJOURNED, immediately objected, said it wasn't in the disclosed evidence. You know, the stuff in bags 1 to 5.
The discovery issue. Yeah, that's fundamental. The defense has to know what evidence is coming.
Precisely. They demanded to see the letter, naturally.
So what happened with the letter?
The prosecution actually withdrew it, officially. Said something about its questionable presentation.
Wow, okay. So they pulled it back. But that wasn't the end of it, was it?
Not at all, because the prosecutor, AWOMOLO, then tried to bring in more stuff. A video and another letter, this one from a former attorney general.
Wait, also not previously disclosed?
Apparently not. Not served to the defense, not even properly filed with the court itself, it seems.
Seriously, that's not standard procedure at all. You have to serve the other side.
Tell me about it. The defense objected, again, obviously demanding proper service.
And the judge. What was Justice Omotosho's take on all this?
Not happy. The transcript says the judge expressed the court hadn't received it either and frowned at the prosecution's actions. Pretty clear signal.
Yeah, judges really don't like procedural games or, frankly, unpreparedness when it comes to evidence. It wastes time and raises fairness questions.
Exactly. So the prosecutor then had to ask for an adjournment.
To get their house in order, basically.
Pretty much. He pleaded for time to, quote, rectify their prosecuting performance and serve the documents properly.
An admission that things weren't handled correctly there.
Seems like it. The judge granted the adjournment to the next day, May 7th.
But I bet there was a condition attached.
Oh, yes. A very firm directive. Justice Omotosho said, and I'm quoting again, henceforth, you must serve all documents you wish to rely upon to the defense team for proper scrutinization and response. I mean, every document.
Every document. That's leaving no room for doubt. Underscores the absolute necessity of proper disclosure.
Definitely. So really, this May 6th hearing became quite focused on these procedural battles and the whole evidence disclosure issue.
It really highlights how these procedural rules aren't just technicalities, are they? They're there to ensure fairness.
Absolutely. The defense questions, the prosecution's fumbles with evidence, it all paints a picture.
And it brings us back to the importance of due process. The judge's firm hand really reinforces that.
It does. So for you listening, it's worth thinking about what it suggests when evidence presentation hits these kinds of bumps. What does it tell you about the process itself in this specific case?
Yeah, definitely something to keep in mind as the trial continues.
Thanks for diving deep with us today.